Alex here with part 40 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the underlying purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. Every 5th video, I also like to let my viewers know about the bell notification, and we're on video 40, part 40, so I'm going to go ahead and do that. Those of you who are wondering why you're not getting every single update, or what do they call it, email notification from YouTube, if you're wondering why you're only getting some of them, it's because you haven't clicked on the bell notification. If you do click on that, YouTube will then begin to send you every single video published, and I assume every single comment that I post to the community tab as well. So moving on, part 39, we left off with myself having filed a motion to resolve this annoying, I was going to say situation, but it's like, a situation almost makes it seem like it just kind of happened. But really what she's doing, what my ex is doing, is playing games. She is claiming to have not gotten an email from me on purpose to try and frustrate me, hopefully to get me enraged or furious, to trigger me. And number two, at one point she claimed having sent me an email notification that she never did. And I'm sure of this, absolutely 100% sure. And this is because of the experience that I have, the memories that I have, and the benefit of hindsight, being able to look back 10 years, literally 10 years, and using all of that knowledge. And most of what she did was to trigger some kind of response from me. And I think I've talked about this in several videos, but the point of the actions they take isn't actually to resolve something or to get something done. It's to see what they can get you to do and see how they can portray or get you to react, or sometimes to fill a false narrative. Sometimes they put together a false narrative and they don't have any proof that you actually fit into that narrative, so they try and trigger a response from you to get you to sort of fit into that role that they kind of put you in. So I have talked about delay tactics in a previous video, literally titled Delay Tactics, and one of the benefits of having set a deadline is that it forces a response from your ex. And this has already happened in my case at least one time, maybe twice, and it will definitely happen in the future. But what we are about to go into right now is it having happened right now. I filed that motion and she stipulated. This is one of the things that I'm going to be taking with me from 2009 onward, is the idea that if she doesn't agree, I'm going to file a motion, unless I don't think I can prevail. You know, if I ask her for something and she says no and I don't think I can prevail, or I don't think it's appealable, I'll usually just let it go. But this is a situation where I wasn't getting to exercise my vacation time because she was deceiving me about having sent an email, and she was claiming vacations when she felt like it, just by lying and saying she sent an email when she didn't. And so I filed that motion because she didn't want to, come to an agreement on it, and it triggered a deadline. She had to file an opposition within 10 days of having received my motion, and what did she do? She stipulated. So definitely take a look at the video Delay Tactics, because I elaborate a whole lot more on this. If you just go back and forth, emailing, calling, talking to them, if they're a high conflict ex, they'll just string you along. There was an example, and I provided that example in that video, of a friend of mine who was strung along for at least a year. I think it was between a year and 12, or a year and 16 months, something like that. And he was not, he wasn't getting joint custody, and she was offering to go out to eat with him and talk about it over lunch or dinner, phone calls, emails, of course, simple stuff, and nothing ever happened. Then he finally filed a motion. She stipulated. After all that time, that's what it took. That deadline is a magical thing. It really is when it comes to high conflict exes. And I think at this point, having said everything that I just said, we may as well go ahead and take a look at what we have filed. here we have the stipulation and order, much like my viewers have seen, or you guys have seen, quite a few videos ago when we resolved the issue with the taxes, claiming our son on our taxes, alternating the years. Same exact thing, another stipulation and order. This one was also prepared by my ex's attorney. The first paragraph identifies both of us, both my ex and myself, and she indicates appropriately that my ex is represented by her and that I am appearing in proper person. First paragraph, she is indicating that from now on we will notify each other of our intent to take vacation time by mailing a certified letter to her current mailing address and vice versa with regards to her to me, and that each of us will notify the other at least 30 days prior to the first day of vacation. This doesn't last long, by the way. I've talked about this so many times. Once you actually cut off the conflict, they stop. And this is the last example I provided was the phone calls. She created this huge debacle with the phone calls by alleging that she wasn't able to call him, even though what she was doing was deliberately calling 1 minute prior to his bedtime. And as soon as the court addressed it in an order, she just stopped calling. She was like, nah. The point was never the phone call. The point was to allege there was a problem. The point was the conflict. Same thing happens here. We are now ordered by stipulation to send this certified letter to each other, which is something that you really can't debate or deny. If she gets a letter sent to her and I have proof of the little certification card that proves she actually got the letter, she's not going to be able to go to court and say, hey, I never got this. It's just not going to happen. So what does she do? This problem resolves itself. I get notification 30 days prior. From then on, this is no longer an issue going into the future, and it's not long before we vacate this portion. After, I can't remember how long, I think maybe it's a year or two, she's like, can we just stop doing the certified letter thing? And I'm like, yeah, we never needed to do that. We just needed to not play games. So this whole thing, once again, you create an order, it's binding, it's enforceable, magically the problem stops. And if it doesn't, there will be contempt motions. And there are examples in my case where there will be contempt motions, at least 3, at most 6, somewhere in the middle. I've lost count of how many times I had to file it. But not always does it have to go that far, but sometimes they want to push it that far, and it's usually because they have overreached. They miscalculated their ability to push a boundary. They went too far. It's not like they on purpose wanted to get held in contempt. It's like they thought they were in the clear. They thought that they weren't violating an order. They went right up to the line. But in reality, they did violate the order, and so that ends up going to a contempt motion. The next line here is that we agree, based on our stipulation, for me to withdraw my motion, that makes sense. And the next one is the boilerplate penalty for violation of order. I've talked about this several times. This is included in every single order that involves child custody, and that is mandated by statute in Nevada. The judge is forced to do this. We got all the signatures at the bottom again. My ex's attorney, myself, and I have no attorney, so it's just me. And then, of course, the judge. A certificate of mailing by the judge. No, what is this? By my ex's attorney, personally served on me. That's weird, because what she would have been doing then is serving me a stipulation with a blank signature line, but the judge did sign it. That's a little confusing. Anyway, let's just go ahead and move past that. I'm not sure how she made that happen. And then we've got these self-help form stipulation and order that her paralegal filled out for her and that she signed. Next document, request for submission. This is the document that sends the order. Well, it doesn't send the order up. What it does is it tells the judge that there is something pending that requires his signature. That's what it does. And it's a stipulation and order, which we both agreed to. And by the way, if anyone's curious, take a look at the video request for submission, because I elaborate a whole lot more as to how this works, and not many jurisdictions use it, not even in Nevada, like 2 or 3 do. Other jurisdictions, you don't have to file this at all. They have their own internal process for figuring out when something needs to be ruled on. Next document, the notice of entry of order. This is the document that lets me know that an order has been entered. My ex's attorney filed it. This implicates the timeline on filing an appeal. I've talked about this so many times, I'm not going to do it again. Instead, I will direct my viewers to the video, notice of entry of order. It's a must-watch. Certificate of mailing, indicating that she dropped it in an envelope and dropped it in the mail, sent it to my address. This is an old address, by the way. All these addresses, guys, this information is ancient, so I'm not concerned. If it's my ex's information, I'll of course redact it. But it's ancient information for her too. Index of exhibits, the order issued. So since we already went over the order, I'm not going to go any further with this document. The exhibit 1 is going to be the exact same stipulation and order that we just reviewed. And as with all my other videos on the My Docket series, down in the description below you will find the links to the actual documents that I'm looking at, and you can always click on a link and download it for yourself. And then of course, if you have any questions that I didn't cover in the video or something to point out to me, you can always mention that down in the comments below. Next document, notice of change of address. I have talked about this at least once prior, maybe twice. I have a video dedicated to this. The notice of change of address is a crucial instrument in most states, and in other states it's still important. Nevada does not require your ex to personally serve you if your case is closed for a certain amount of time, like other states do. Like for example, California. If a final order has been entered in California and a certain amount of time has passed, your ex has to track you down and serve you again personally. So if your address has changed, it's not a big deal because they actually have to find you. But in Nevada and many other states, this is not the case. If your ex needs to serve you, and it's been years, they can still serve you by mail, especially in a child custody action, because it's considered one of those things that everybody knows is going to be open until the child turns 18, and one of those things that you need to stay on top of. So it's important that you file a notice of change of address to let your ex and the court know that your address has been changed, because then if they serve you by mail at your old address, you won't get screwed over. And I hate to use that word, but that's really what happens. It does happen to people. Please watch the video notice of change of address, because I explain how important it is for my viewers, especially those representing themselves, because you don't have an attorney that's going to be taking your mail, for you guys to update your address to make sure that when you move, any new paperwork filed in your court action gets mailed to the correct address. Don't play around with this. Affidavit, which is just indicating that, what? Oh, this is ridiculous. This is something that's required when you file a motion. So here I don't know this because I'm representing myself, and I'm including an affidavit with a notice of change of address. It's silly. You know, there's no facts alleged in this notice that need to be sworn under penalty of perjury. So it's fine. It's not going to hurt my case that it's there. It's just kind of silly. Next, we have the affirmation pursuant to that statute, the Social Security number statute. Let's the clerk of the court know that this document does not contain a Social Security number. Next document, affidavit of service, and it's most likely the one of the notice of change of address that we just went over. And this is a personal service, so I went to my ex's attorney's law office and hand delivered that notice of change of address. Affirmation, again, just letting the clerk of the court know that this document also does not contain a Social Security number. Next document, I moved again, another notice of change of address. And in this document, I am just indicating that my address has changed, as with the previous one. And what do we have here? I'm also trying to change the exchange point. Or I'm trying to indicate that there's a oh yeah, I'm adding a designee. And that is a person who's just got the right to pick up, our son for me. I can't even remember this person. Amy. Doesn't ring a bell at all. No clue who that is. Anyway, probably a friend from work or a coworker. Something like that. I wish I could remember, but it's 10 years back. I'm sorry. Scrolling on, we see the affidavit. Again, not necessary for a notice, but it's there. And then we've got the affirmation. Next document, another affidavit of service. And this is personal service of that notice of change of address. The second one, again, taking it to my ex's attorney's law office and physically handing a copy of that over to the lady working behind the desk or counter. Another affirmation, again, letting the clerk know that no Social Security number is included. If anyone is wondering, each video typically covers a main paper of some sort, and in this case it's a stipulation and order. And then what I do is I look forward to see if there were a bunch of ancillary filings, stuff that really, it would be silly to make its own video on. Like, seriously, I'm not going to do a video on the notice of change of address or a request for submission. That paperwork is just like a 1 or 2 page thing that sort of glues other things together. In this particular situation, after the stipulation and order, there just happened to be, coincidentally, 6 of these ancillary documents that really don't deserve to have their own video. There's nothing complicated about them. It would be a waste of everyone's time to watch a video just on one of those topics. So I lump all of those into the video, to the main thing that I'm trying to cover in the particular video. And today, that main thing is a stipulation and order. And we just so happen to have 7 documents, ancillary documents, 1 to 2 page pieces of paper that that just need to be covered as well because they're not important enough to have their own video on. And I mentioned that there were 7 of them, that I haven't gone over the 7th, and we'll do that now. That is the acknowledgement of receipt of fictitious physical address. This is a paper that my ex's attorney asked me to sign so that she could file it with the court and let the court know that my ex had complied with the judge's order to turn over an address to me. And she's letting the judge know that she did turn over an address. However, it's a fictitious one under the confidential address program. I've talked a whole bunch about this, and we're going to hold off because that conflict is not going to kick off for some time. Certificate of service by my ex's attorney indicating personal delivery. I was there when I signed it, so she just handed a copy to me. Going into the aftermath, I filed 5 of those documents, but they were all free filings, so I incurred $0 in costs. My ex's attorney filed 3 of those documents. Those were also free filings, so she also incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, let's say she spent 5 minutes on the acknowledgement because it's just like a 2-line thing saying I got the fictitious address. The review of the affidavits of service, the notice of change of address, that kind of stuff, I'm going to say 5 minutes. I'm going to lump it all into 5 minutes for those 4 documents. So we're at 10 minutes so far. Notice of change of address, it's one of those form documents. In fact, the request for submission is also. So for both of those, I'm going to say 5 minutes. So we're at 15 minutes right now. Stipulation and order, she would have had to prepare that and also communicate with my ex. So that is definitely something that's going to have a lot of back and forth. Knowing how my ex, she doesn't want to agree. She would prefer to fight. I'm sure that her attorney was probably really twisting her arm to get her to agree to that. It was just not a fight that she was going to win. It was just pointless. So I'm going to assume that she didn't spend too much time trying to get my ex to agree. And I'm going to say 45 minutes, counting not only the communications back and forth, but also the preparation of the document itself, which is going to bring us up to an hour, which is going to come to a total of $250 in attorney fees for my ex. If anyone has any questions, feel free to post them down in the comments below, and I will see you guys next time.